If you have been waiting for your green card, if you have been stuck in the backlog for months or even years, if your family has been in limbo wondering when you will finally get stability in this country, I need you to stop what you are doing and listen very carefully. Because what I am about to share with you is not speculation. This is not rumor. This is confirmed policy change that just happened in February 2026, and it is affecting tens of thousands of skilled workers and their families right now as we speak. We are looking at 3 separate victories that all converged in the same month. The Visa Bulletin just moved forward for EB-3 skilled workers. A brand new weighted H-1B selection system takes effect in just days on February 27th. And the President just signed legislation extending protections for religious workers and their families. If you are in any of these categories, or if someone you love is waiting for their green card, this video could directly impact your next steps. Do not scroll away. Do not assume this does not apply to you, because by the end of this video, you will understand exactly what changed, who benefits, and most importantly, what you need to do right now. My name is Raymond Crivello. I am a senior immigration analyst and consultant, and on this channel, I break down complex immigration developments into clear, fact-based analysis you can actually understand. I have spent years studying immigration policy, regulatory changes, and USCIS procedures, and my only goal is to give you the truth. Not sensationalism, not fear-mongering, just the facts you need to make informed decisions about your immigration journey. Now, before we go any further, I need to be very clear about something. I am not your attorney, and this content is for educational and informational purposes only. Always consult with a licensed immigration attorney about your specific case. Every situation is different, and nothing I say in this video should be taken as legal advice for your individual circumstances. What I can do is help you understand these policy changes so you can have more informed conversations with your legal counsel. Now let us dive into the first and arguably the biggest victory of February 2026. I am talking about the Visa Bulletin advancement for EB-3 skilled workers. The U.S. Department of State has just released the February 2026 Visa Bulletin, and what we are seeing is significant forward movement in the EB-3 category. For those of you who may not be familiar, EB-3 is the employment-based third preference category, which includes skilled workers, professionals, and other workers. This is where a huge portion of employment-based green card applicants fall. Here is what specifically happened. The final action dates for EB-3 have moved forward by 3 months for Mexico, the Philippines, and the rest of world category. Now I know 3 months might not sound like a lot to some of you, but here is where this becomes critical. Since May of 2023, we have seen significant retrogression in this category. That means the dates actually moved backwards, and thousands of people who were close to filing their adjustment of status applications suddenly found themselves ineligible again. It was devastating for so many families. But now, with this 3-month advancement, we are seeing the tide begin to turn. Thousands of applicants whose priority dates were stuck just beyond the cutoff are now suddenly current again. And what does being current mean? It means you can finally file your I-485 adjustment of status application. It means you can finally move from being in the backlog to actively having your green card case adjudicated. For your family, it means H-4 dependent spouses and children can also file their I-485 applications. It means work authorization through employment authorization documents becomes accessible. It means stability that many of you have been waiting years to achieve. I want to show you exactly where this information comes from. This is directly from the U.S. Department of State's official Visa Bulletin for February 2026. You can see right here the advancement in the EB-3 category. This is not speculation. This is not rumor from social media. This is official government documentation that you should screenshot and share with your attorney immediately if you are in this category. But here's the thing. This is what many green card applicants are misunderstanding. The Visa Bulletin advancement is just one piece of what happened in February 2026, because just 5 days from now, on February 27, 2026, a completely new rule takes effect that could fundamentally change how skilled workers enter the green card pipeline in the first place. I am talking about the new DHS Weighted Selection System for H-1B visas. Let me explain what this means because it is genuinely unprecedented. The Department of Homeland Security has finalized a rule that changes how H-1B lottery selections work. Under the previous system, every registration had an equal chance of being selected in the lottery. One person, one entry, same odds for everyone, regardless of salary or skill level. But starting February 27, 2026, that changes completely. Under the new weighted selection system, workers will receive lottery entries based on their wage level as determined by the Department of Labor's prevailing wage system. Here is how it breaks down. Level 1 wage workers, which are typically entry-level positions, receive 1 entry in the lottery. Level 2 workers receive 2 entries. Level 3 workers receive 3 entries. And Level 4 workers, which are the highest paid professionals in their occupations, receive 4 entries. This means that if you are a Level 4 worker, your chances of being selected in the H-1B lottery are effectively 4 times higher than someone at Level 1. Now, there is one detail most people are missing about this rule, and it directly connects to the green card conversation we started with. Think about what this means for the employment-based green card pipeline. When higher skilled, higher paid workers have a better chance of getting H-1B visas, it means more workers are entering the system who will eventually become strong candidates for employment-based green cards. It means employers are incentivized to sponsor higher-level positions. And perhaps most importantly for families, it means the workers who do get selected have more stable, higher-paying jobs that can better support their families through the years-long green card process. For H-4 dependent spouses and children, this stability is everything. The green card wait can take years, sometimes over a decade for certain countries. During that time, family members are in a precarious position. H-4 children age out. Spouses may or may not have work authorization depending on complex eligibility rules. Higher job stability and higher income for the principal H-1B worker translates directly into more security for the entire family unit. Again, I want to emphasize this is not speculation. This is a finalized rule from the Department of Homeland Security that has completed the full regulatory process. It was published, there was a comment period, and it has been finalized. February 27, 2026 is the effective date. If you are an employer or a prospective H-1B worker, you need to be having conversations with Immigration Counsel right now about how this affects your 2026 registration strategy. This could affect you even if you are not in the H-1B or EB-3 category, because the third victory I need to tell you about affects a completely different group of workers and families. I am talking about EB-4 religious workers, and what just happened on February 3, 2026, when the President signed H.R. 7148 into law. Let me give you the background on why this matters so much. There is a special immigrant category under EB-4 for religious workers who are not ministers. These are people working for religious organizations in professional or other capacities, people who have dedicated their lives to religious service but may not hold formal minister titles. For years, this program has operated under temporary authorizations that Congress has to periodically renew. And every single time that renewal comes up, thousands of religious workers and their families hold their breath wondering if they will lose their pathway to permanent residency. H.R. 7148 has now extended the non-minister Special Immigrant Religious Worker Program through September 30th, 2026. What does this mean practically? It means that religious workers who were terrified their status would expire now have a clear runway to continue their green card applications. It means families who have built their lives around religious service in the United States can breathe a little easier. It means the uncertainty that has plagued this community for months has been resolved, at least through the end of fiscal year 2026. This information comes directly from USCIS's official guidance on the extension of the EB-4 Special Immigrant Program for February 2026. If you are a religious worker or your organization employs religious workers in non-minister capacities, this is critical information that should be shared immediately. Now I want to take a moment to put a human face on what these policy changes actually mean, because it is easy to get lost in the legal terminology and the regulatory procedures. But behind every visa bulletin advancement, behind every rule change, there are real people with real families whose lives are directly impacted. Let me tell you about a situation that represents what thousands of people are going through right now. Imagine Priya. She is a software developer who came to the United States on an H-1B visa 7 years ago. She has worked hard. She has contributed to her company. She has paid her taxes. She has built a life here. Her employer filed her perm labor certification years ago, and her I-140 immigrant petition was approved. But then came the EB-3 retrogression in 2023. Her priority date was just 2 months beyond the cutoff date. So close she could almost touch it, but not close enough. For nearly 3 years, Priya has been stuck, unable to file her I-485, unable to get her green card, living in constant uncertainty about her future. Priya has a husband on H-4 status who cannot work because she is not yet eligible for I-485 filing. She has a daughter who was born here in the United States and is a citizen, but Priya herself remains in temporary status. Every time there is talk of layoffs at her company, Priya feels her stomach drop because losing her job would not just mean unemployment. It would mean potentially losing her ability to stay in the country she has called home for 7 years. But now, with the February 2026 Visa Bulletin advancement, Priya's priority date is finally current. She can file her I-485. Her husband can file his I-485 as a dependent. He can apply for an employment authorization document and finally contribute financially to their household. After years of waiting, they can finally see the finish line. Priya's story is not unique. Right now, as you watch this video, there are thousands of families just like hers who are either celebrating this news or desperately trying to figure out if it applies to them. And that is exactly why I make these videos. Because immigration policy should not be mysterious. It should not be confusing. You deserve to understand exactly what is happening and exactly how it affects your case. So let me give you a concrete action plan based on everything we have discussed. If you are affected by any of these 3 victories, here is what you should do right now. Step 1. Check your priority date against the February 2026 Visa Bulletin. If you are in the EB-3 category, look at both the final action date and the dates for filing chart. Understand which one your attorney is using for your case. If your date is now current, you may be able to file your I-485 immediately. Step 2. Gather and organize your documentation now, not later. If you are newly eligible to file I-485, you will need birth certificates, marriage certificates, passport copies, photos, medical examination results from a USCIS designated civil surgeon, and various other supporting documents. The sooner you start gathering these, the faster you can file once you confirm eligibility with your attorney. Step 3. Avoid any status violations during this critical period. This is not the time to take risks with your immigration status. Do not let your visa expire. Do not engage in unauthorized employment. Do not travel without confirming you have valid travel documents. One mistake now could derail everything you have worked toward for years. Step 4. Be extremely cautious of immigration scams. Whenever there is positive news in the immigration world, scammers come out of the woodwork promising fast green cards and guaranteed approvals. There are no guarantees in immigration law. Anyone who tells you otherwise is lying to you. Work only with licensed attorneys who are in good standing with their state bar associations. Step 5. Consult with a qualified immigration attorney immediately. I cannot emphasize this enough. Every case is different. What applies to one person may not apply to another. An experienced immigration attorney can review your specific situation, confirm your eligibility, and help you develop a strategy that maximizes your chances of success. However, this protection may not be permanent, and I want to be very honest with you about what comes next. We need to discuss the broader policy context so you understand both the opportunities and the uncertainties ahead. The EB-4 Religious Worker Extension through HR 7148 is only until September 30th, 2026. That means in about 7 months, Congress will once again need to act if they want to extend this program further. We have seen these programs extended many times before, but it is never guaranteed. Religious workers and their employers should be using this window of stability to move their cases forward as quickly as possible. The weighted H-1B selection rule is a finalized regulation, which means it has more permanence than temporary congressional authorizations. However, regulations can still be challenged in court. We have seen other immigration regulations face legal challenges that delay or block implementation. As of now, there are no major legal challenges to this rule that I am aware of, but that could change. The immigration policy landscape is extremely dynamic right now. The Visa Bulletin is particularly unpredictable. Just because we saw a 3-month advancement in February does not guarantee continued forward movement. We have seen periods of advancement followed by sudden retrogression before. The State Department adjusts dates based on demand and the number of visa numbers available. My advice is to take advantage of forward movement when it happens, rather than waiting to see if dates advance further. What I want you to understand is that these 3 victories represent real, meaningful progress for skilled workers and families. But immigration policy in the United States remains complex, uncertain, and subject to change. That is not meant to discourage you. It is meant to motivate you to take action now while the window is open, rather than assuming these favorable conditions will last forever. I want to leave you with this thought. Immigration status affects every aspect of your life. It affects your family unity, whether you can live with your spouse and children in the country you call home. It affects your employment stability, whether you can work, advance in your career, and build wealth for your family. It affects your financial security, whether you can plan for the future, buy a home, save for retirement, invest in your children's education, and it affects your long-term residency and citizenship plans, your ability to truly put down roots and build a permanent life in the United States. These are not abstract policy discussions. These are the foundations of people's lives. That is why I take this work so seriously. That is why I spend hours researching every policy change to make sure I am bringing you accurate, reliable information. And that is why I will continue to be here, breaking down every development as it happens, so you never have to wonder what is really going on with your immigration journey. If you want accurate, fast, and reliable immigration updates, subscribe to Raymond Crivello right now and turn on notifications. Immigration policy is changing rapidly, and staying informed is no longer optional. It is essential. I want to hear from you. Drop a comment below and tell me your visa category. Are you EB-3, EB-4, H-1B, something else entirely? Let me know what questions you have about these February 2026 developments, and I will do my best to address them in future videos. If you know someone who is affected by these changes, someone waiting for their EB-3 green card, someone preparing for the H-1B lottery, someone in religious work wondering about their future, please share this video with them. Information is power in the immigration world, and sharing accurate information could genuinely change someone's life. And if you found this video helpful, please hit that like button. It helps the algorithm share this content with more people who need to see it, and it supports factual immigration coverage over sensationalism and rumors. Thank you for trusting me with your immigration education. I am Raymond Crivello, and I will see you in the next video with more updates you need to know. Stay informed, stay prepared, and stay hopeful.